Here, the Court of Appeals of the State of Michigan is now in session. The Honorable Colleen A. Ryan, the Honorable James Robert Redford, and presiding the Honorable Anna, all persons having business herein, draw near to the attention, and shall be heard.
All right, we're going to see if we can do better than yesterday. Good morning.
Morning.
Okay.
Marginally better. But yeah.
Marginally better. Okay. So on behalf of myself and Judge O'Brien and Judge Redford, I'm going to welcome you to the second day of our Detroit Case Call Panel number 2. We see some familiar names on our call today, and we know that these cases are important. We've been diligently working on these matters. We've had the benefit of your briefing and the work of our research division and our chambers. So I can assure you, as you can see by our piles here and our iPads, that we're very familiar with the relevant facts and the pertinent law. And so we'd ask you to focus on your salient points, keeping in mind our role as an error correcting court. Because we will be hearing matters today involving sexual assault victims and children, and because these proceedings are recorded, please keep that in mind and substitute initials in lieu of using a victim's, a petitioner's, or minor's full name in those cases. And for those of you that are new to the court, welcome. The only rule that I want to make you aware of is if you are endorsed for oral argument and there are 2 sides endorsed, you each have half an hour. If there's only one side endorsed, you have 15 minutes. I don't imagine that anyone will take the full half hour, but I said that yesterday and it didn't work out for me.
She jinxed us.
Yes, but we're looking forward to hearing your arguments. And today we'll begin by calling item number 15, docket number 378936, People of the State of Michigan versus Ronald Larvette Hill.
Good morning, Your Honors, and may it please the court. Joshua Miller from the Oakland County Prosecutor's Office on behalf of the plaintiff appellant, People of the State of Michigan.
Okay, as he just checked in? Okay, can we give him?
I will pause.
Yes.
Thank you, Mr. Miller.
Dramatic entrance. It's not the easiest building to get into or park or. Good.
Well, we came out a little bit early.
We did.
That's okay. That's okay.
Judge Letic had made us. So.
I mean like that. So go ahead, Mr. Miller.
Again, Joshua Miller on behalf of the plaintiff's appellant, People of the State of Michigan. Your Honors, I'm certainly not going to take the full half hour allotted to me for argument. The relief I'm requesting on behalf of the people is actually somewhat unusual. I'm asking the court to make my job, or more precisely, the job of the trial prosecutor who's handling this case, more difficult than the trial court wants to make it with the jury instructions. We have this issue floating around of Counterman versus Colorado requiring recklessness as the mens rea in threats cases as the constitutional minimum. But we have an ethnic intimidation statute in Michigan, or at least it was the ethnic intimidation statute. It's since been amended to the hate crimes statute, but it still maintains some of this language that requires specific intent and malice on behalf of the actor. The defense, of course, seems to have shifted their focus since the prior interlocutory appeals in this case from the recklessness issue to the reasonable person standard being included. Counterman did not preclude a reasonable person standard. It just said it cannot be the sole standard by which the words are judged as to whether or not they are a threat. So our statute is actually more protective because it includes both. So you have to have a threat that's made with malice and specific intent, and there has to be reasonable cause on the part of the person hearing it to believe that that person will follow through with that threat. So this is far more protective than the stalking statute that was at issue in Counterman. It's very similar, as my brief argues, to the FASNICA, where this court compared one subsection where there was a knowing standard versus another subsection where there was nothing. Here we have that intent. So I'm simply asking the court to reverse the trial court, remand with instructions to provide the jury instruction that people drafted, which inserted the specific intent, which was not included in the standard jury instruction. And unless the board has any specific questions for me, I would otherwise rest on my brief.
Do you think this case should be published?
I think, given that some of the language has carried over to the amended statute, it would absolutely be informative, not just for this charge, but also for any charges going forward. So I would ask the court to strongly consider publishing.
Couple of questions. You've read opposing counsel's briefs.
Yes.
He, and I don't presume to speak for a very, very capable counsel on both sides of the being the case, but it certainly sounds like his issues are there are a lot more issues from his perspective than you suggest. Do you agree with that assessment of his pleadings?
I agree that that's his position, and I disagree that
All right.
there are.
Why do you disagree?
Because our statute is very straightforward. All of these issues with recklessness, reasonable person, as I mentioned in Counterman, when you talk about the reasonable person standard, if Counterman doesn't say you can never have this, it just says you can't be the only standard.
Okay.
And then as for the recklessness, it's been actually very admittedly hard to track the defense's arguments because they sort of shift on the recklessness argument, and he seems to be minimizing that now. At least that was the impression I got from his brief. He says, well, you can put the specific intent back in, but then he focuses on the reasonable person standard. So I think based on the plain language of the statute, there are not issues here. When the court case was bound over, it was bound over with that specific intent in mind. It was bound over with the statutory language in mind. So I don't see all of these issues that the defense seems to believe are present.
Okay. Next question is, if you believe that whatever we decide as a panel should be published, what specifically are you seeking? Are you seeking, give us the actual, this is the charging instruction. You want us to draft that? Or do you want us to say, here are the port and starboard running lights, and you got to keep the vessel navigating between those? Court, you decide yours. What are you looking for? Because, and I asked this because I had the privilege of being a member and then the chair of the Model Civil Jury Instructions Committee, and that was a very comprehensive process with every side of the bar and bench represented, and it was a very careful and detailed process where we gave model jury instructions to the bar and to the courts. What are you looking for from this panel?
We're looking specifically for the guidance that when a statute includes a mens rea and the jury instruction doesn't, it's proper for the court to include that language. I don't know why the model criminal jury instruction doesn't already include this, because the statute has not been, until the hate crimes amendment recently, was not amended since it was enacted in the late 80s. And
maybe no one has asked for one, because that is usually the triggering
Correct.
event
Correct.
which starts it, whether it's a judge or a bar association.
and I think Counterman may have been what finally triggered people to at least think about this. But
You
but
think?
what we're looking for from the court is to communicate to the trial courts, this one specifically, but in general, that when the statute includes a specific intent, you can put that in. You're not looking at Counterman, you're not looking at recklessness if it includes knowledge or specific intent or malice.
All right. Thank you. Thank you, PJ.
I think
Thank
we're
you.
all set.
I'll reserve any
You
time
have,
for
you have
rebuttal.
time
Thank
for
you.
rebuttal.
May it please the court, Michael Comort on behalf of Ron Hill. At the offset, I want to say, I do not want to be a attorney that is standing in the way of the people setting a higher standard of proof that they would have to establish a trial. I am not. That's not our position. In fact, I would invite court to come up with the highest possible standard of proof. And many additional,
And publish
elements.
it.
And, if you can come up with a higher, then beyond a reasonable doubt, use that too. But I don't want any of my arguments to suggest that, whatever the determination is, whether it's, malice with specific intent or reckless, And I can explain why I was arguing reckless at the time, but I don't know that it's necessary. I'll give that, let it be said on this record that I'm agreeing with the government on this one, okay? But I do think not really addressed and in their brief so much is the issue of this, the listener as being the evidence and the culpable, deciding the culpability based on their reasonable beliefs of a threat of a battery to occur in the future. I mean, this situation, even though we dispute what was said, there's a moment in this narrative where my client is sitting in the back of a Uber, he's being driven, he's described as sleeping, laughing, giggling, a menagerie of emotion. But nevertheless, the event that is described, you kind of track at that Telegraph and 696, if anyone is familiar with that area. And once you pass Telegraph, which is the moment that the words are spoken, there's a 4 or 5 mile ride before you can get off on any road, which is Orchard Lake Road. So that period of time is, factually speaking, the assertion of whatever said occurs at the Telegraph. She can't get off for 4 or 5 miles. It's, maybe 7, 8, 10 minutes.
Oh, she's on 696.
She's 696.
Oh, okay.
So,
All right.
so the statute is like, that the threat of the battery would reasonably occur in the future. So here we have a period. It doesn't occur in the first second. It doesn't occur in the first 5 minutes. And where's the limit to this? Is it infinite? When she gets home that night or 3 days later, she thinks, it's problematic. The language there, not just from that situation as applied to my client, as applied here, but, in light of Counterman, which clearly sets the new standard, a new bar, and defines what constitutional threat speech is. And that is to focus on the speaker and their intentions of conveying the threat speech to the listener with the knowledge and specific intent. Counterman uses reckless, that will be received as by the listener. The unconstitutionality of that is that the listener gets to decide for multiple reasons. But the ethnic intimidation statute, which no longer exists, it was renamed and the hate crimes statute is, I believe, was instigated by the Counterman, and clearly they used the definition of threat speech and turned the focus of the elements of that particular new statute, the hate crime statute, on the speaker and the speaker's intentions. But the ethnic intimidation, which doesn't even exist really statutorily, has a malicious and specific element of the intention of the speaker. And but at the end of the day, it still revolves around the listeners, reasonable beliefs, which to me is exactly what Counterman says is the unconstitutionality. I have been arguing that, and that was really, when we go back to the, chart my motions and, applications for appeals and reconsiderations, my entire focus has been on trying to embrace what Counterman said, which was the focus should be on the speaker, not the listener. Now, I realize that both of those two things can exist at the same time, I would think. In that jury instruction, you could have, for context, I guess, but not as a sole determining factor, that if the listener was put in fear or reasonably believed, that should not be something that the jury should be considering. I think that, maybe they could testify about that, those kind of things, but it shouldn't be just for context of, I don't even know if I'd concede that. I would say, it becomes irrelevant because there's not a fact on the record for my client, just as a matter of fact and law, that anyone has ever offered or said what his intentions were, other than, these alleged words were spoken. There's nothing that's been offered in any context that would support the principles and, the bar by which Counterman sets, which is the focus on the speaker. I could go on. I don't know if the court had any questions or Um,
Do you want to speak to, I'm going to mispronounce it, Kavinsky,
but yeah,
Kavinska?
well, I like that the Court of Appeals found it unconstitutional. I will say that. And the Court of Appeals went to great lengths to defend itself. And then the Supreme Court said, we read an opinion that, you know, is against, and I would say that just I don't think the Court of Appeals is looking usually for unconstitutional holdings. I think that they genuinely made that call because they thought it was there, according to Counterman. I think if we're, you know, if that is Michigan's jurisprudence now, and this event here, this exercise is to, you know, give direction on how to fix the jury instructions for a trial where a statute might have been, you know, not necessarily well written in the context of Counterman, then I would say that that's what we should do. We should be figuring out the anchors of what needs to be within the jury instruction, and, you know, recognize at the same time we are repairing a broken statute at the end of the day. I mean, Judge McMillan's, you know, opinion, which I thought was not, you know, may have been understated in the pleadings, but I had filed a motion to quash the bind over, and she denied as, you know, on its face, but as applied, she denied it without prejudice based upon her reading of the ethnic intimidation jury instruction, which, you know, had missing elements from the statute itself, but certainly had no language whatsoever about the defendant's intention. And it was completely reliant upon the listener's impressions. So she identified that as written and as applied to Mr. Hill, my client. It is unconstitutional as applied. So the endeavor after that was trying to fix the jury instruction, you know, of what was really, you know, which in light of Counterman was a not well-written statute.
Would a jury instruction that required the petite jury to find that there had been a malicious threat communicated by the accused, and that it was done with the specific intent based on the race or color or other protected status to intimidate, would that be enough?
If we're just talking about that first line, I'm not disputing we can use malicious, you know, with specific intent. I'm not disputing that. At the time in front of Judge Rowe, I was literally for credibility purposes arguing standards straight out of Counterman, which was using the reckless, which they called the bottom line bar. You know, it's not the middle, but to say it at least has to be reckless. So that was
right. But isn't there jurisprudence in our state that malicious is higher than reckless?
I don't dispute that. And I'm not, but my focus at the time was to say, Counterman says reckless, but Counterman also says that you can't have a statute, a person can't be convicted based on a listener's feelings. It's got to be that's all, that was my fight. Okay. So I was, you know, and instead of, I mean, you know, afterwards it's a silly fight to argue against the government's, you know, higher bar. But I was literally doing it for credibility purposes with Judge Rowe, because if it came down to it, it's like, where are you getting that from, counsel? I was going to say Counterman, and Counterman supports reckless, and Counterman, most importantly, supports not using the objective or focusing the culpable behavior on the speaker. If, you know, the state is, you know, reads Counterman to include both, you know, the objective listener and the speaker. I don't think it goes that far. I think it's really focused on the speaker and their intentions. But I digress, Your Honor. But you know, that's an important point. I think if anything that I'm coming out of this saying, if I could summarize, I'm fine with accepting. I do think Judge Rowe was concerned that if we had different standards like malicious with specific intent and or reckless somewhere, they were going to be confused with those things. So once we got going on replacing the first one with the reckless, I think it kind of, you know, so again, I stand here and say, let's use the highest standard for all of the instruction. I have no problem with that. I'm not going to argue that my main concern was that this jury should not be told that they could assess the evidence from the listener's perspective or, put themselves in the shoes of the listener and draw and based on those feelings, say that this is threat speech. That cannot be the case. There has to be proof that when he said it, or when the speaker said it, it contained malice, specific intent, recklessness, all of that. So that's our position. If I made myself.
Thank you.
Thank you.
Mr. Miller.
Three very quick points in rebuttal, Your Honors. First, I think it's very clear that counsel and I read Counterman differently. I think pages 70 and 71 of the Counterman opinion are the crux of that particular difference. My view, and I think the view supported by a plain reading of Counterman, is that the reasonable person standard cannot be the sole basis upon which to judge. Counsel views it differently and says that, oh, that's unconstitutional in all circumstances. So I think that is ultimately going to come down to what the court believes that portion of Counterman says. So I believe that to Your Honors. The second point, I believe the statute is clear. It's just the jury instruction that is not. So that's why we're asking that the jury instruction be fixed. Counsel is absolutely correct that Judge McMillan, when she was handling the case, did identify the jury instruction as being constitutionally infirm because it did not include any part of the subjective standard. So that is what we have been endeavoring to fix through our differing approaches. And last, on the point of intent that counsel's making, I think it's not any surprise that intent can be inferred from circumstances, and ultimately it's going to be a jury question. So unless the court has any other specific questions for me.
You said pages 70 through 74 of Counterman?
I believe it was 70 and 71 were the most pertinent.
But to what issue?
To the issue of whether Counterman is saying you cannot have solely the reasonable person standard, or whether it's saying it is unconstitutional in all instances. I believe when you read that portion of Counterman, it just says this cannot be the sole basis upon which a threat is judged. Defense, if I'm correct assessing their argument, believes that part of Counterman says you can never have a reasonable person standard, even if you also have the subjective standard like we have here.
Okay, understand your position. Thank you.
Thank you.
Any other?
Great.
No, thank you very much.
That matter is submitted. Calling item number 16, docket number 371815, people of the state of Michigan versus Delano Jermaine Reeder. You may proceed.
Good morning, Your Honors. Jessica Lewis with the State Appellate Defender Office, appearing on behalf of Mr. Delano Reeder, who I believe is downstairs and will be joining us in the courtroom today. I would like to focus my time this morning on the first issue concerning the Brady violation, unless Your Honors have questions regarding the other four claims.
Go ahead.
To start, the prosecutor's brief does contain a number of factual errors that our office was not able to address due to the late filing of the brief. However, I just want to focus on the most relevant misstatements today. First, Mr. Elaine's testimony at trial was critical because he was the only witness to say that Mr. Reeder had a gun or had the gun that was found in a crowd of 10 other people and that was directly beside another person. Under both Giglio as well as People v. Christian, our Supreme Courts have told us that where you have a witness who provides the only direct link between the evidence and the defendant, that person's testimony is key, such that evidence that would have undermined their credibility must be disclosed under Brady.
Didn't Officer Turner, although he wasn't sure it was a gun, he did see the defendant with something dark in his pants, and then he later saw him throw the object and heard it hit something. So there was some corroboration of what Officer Elaine had said?
Partly. So Officer Turner does not state that he ever saw Mr. Reader throw anything. He actually says very explicitly that he did not see him toss anything. And it's not contested the actual things that he does say. He states that he saw Mr. Reader reach and grab an object. That's not contested here. Mr. Reader himself testified that he was grabbing a lighter and cigarettes. Officer Turner testified that when they reached Mr. Reader, he was standing still and smoking a cigarette. Officer Turner testifies he heard a loud clunk noise. It's not contested in this case that there was a gun found on the ground. The only thing that Officer Turner does not state is that what he saw Mr. Reader grab, which again, he said that he could not identify or see, was the gun that was found on the ground. He does not ever make that logical, or not logical, he does not ever make that factual leap. The only person who actually does is Mr. Elaine. He's the only person in this case who definitively states that Mr. Reader was carrying a gun and states that it was the same gun that was found again in a crowd of 10 other people. And it's for that reason that both the prosecution as well as the defense focused on Mr. Elaine in their closing arguments. The prosecution told the jury that there was no reason for Mr. Elaine to lie, and they used Mr. Elaine's testimony, not Officer Turner's, not the video, for proof of the elements of its claims. And for its part, defense told the jury that Mr. Elaine was not a credible witness and focused on the fact that they should not believe his testimony. And again, for that reason, he was a key witness at the trial, and the evidence that undermined his credibility should have been disclosed. Now, the prosecution states that there was no disclosure obligation because they have created a new Brady rule. That is, that evidence must be admissible in order for it to be disclosed. But that is simply not the law. In the case that the prosecution cites, Wood v. Bartholomew, the U.S. Supreme Court looked at polygraph results and whether or not those results were material under Brady, not favorable. The prosecution locates its own made-up test in the wrong prong. And when stating in Bartholomew that the polygraph results were not material, the court gave 4 distinct reasons. First, under state law, the polygraph results were not admissible even for impeachment purposes. 2, that same law prohibited any mention of the polygraph results, either in argument or witness questioning. 3, the only conceivable use of those results was to force a confession from a witness, a confession which itself would not have been at odds with the evidence produced at that trial. And lastly, the trial counsel in that case had actually testified that he could see no conceivable use of the polygraph results, and they would not have helped his defense strategy. The holding of Bartholomew is narrow and limited to the facts of its case. And for that reason, every federal court of appeals to have looked at that case afterwards has stated that it did not create an admissibility requirement under Brady. Indeed, it has been 30 years since that case was passed, and the prosecution does not cite a single case to support its broad ruling of Bartholomew. It still remains the law that if there is evidence that undermines the credibility of a key government witness, it must be disclosed. Now, the prosecution also mischaracterizes the records that were turned over by the DPD in response to our FOIA request. I think it's clear that those 5 categories of record show a picture of an officer who resigned in disgrace. I'm not going to get into every category unless your honors have questions, but I do want to focus on the deposition testimony because there was significant disagreement between the 2 briefs about what those testimonies show. It's Mr. Elaine in the prior deposition does provide false testimony under oath. Now, the prosecution said it does not matter because he was not intending to lie. But if you knowingly state a false or knowingly make a false statement under oath, you have lied, and that information needs to be disclosed to defense. And I think it's important to actually note what Mr. Elaine lied about. When asked how many sustained complaints that he said he had 1 sustained complaint for his partner playing loud music, and he had received 1 warning for chasing a guy with a pistol without activating his camera. But the DPD's own records show that he had 8 sustained complaints against him at least, and from what we can tell, none of them dealt with playing loud music, and none of them dealt with chasing somebody with a gun. Mr. Elaine, after 3 hours or over 3 hours of testimony, then stated that everything that he had testified to was false. The problem with that is that the testimony that he had already given did line up with the actual evidence of the case. Therefore, there were two possibilities. One, he was lying, and that evidence needs to be disclosed to defense. Or two, he is having issues with memory and ability to accurately recall the actual details of his arrest, because as he said, all of his arrests are one and the same, minus small details. And again, that information will need to be disclosed to defense because memory and ability to recall are relevant questioning for cross-examination. And Mr. Lane also lied about the reason that Mr. Pride was stopped in the first place. He stated that they had a reasonable suspicion to stop Mr. Pride because as the police car rode up, Mr. Pride attempted to desperately jump into the backseat of a car. Upon finding it locked, he then jumped into the passenger seat.
And we're talking about a different case here. This is not this case. This is an unrelated civil suit.
That's correct. But I think it's important, one, because it's relevant that he did lie under oath. And two, the circumstances in Mr. Pride's case do line up with Mr. Reeder's. For example, Mr. Elaine does testify that but for Mr. Pride walking in the street, he would not have actually stopped Mr. Pride. And then he testifies as to his common practices, which are that if he sees somebody walking in the street, he stops that person or that opens that person up to investigation by him. Once that person commits a civil infraction, like walking their dog in the street, he finds a gun 9 times out of 10, and that he's never been wrong about his identification of a gun. But most importantly, he states that he knows that a person has a gun because if they're walking in the street or standing with a crowd of people and the police roll up and they step away, or if they are standing near their car and they press their right side, then he knows that that person has a gun. And that is precisely what happened in this case. Mr. Reeder was walking down the street near his car. The police car turned onto Carey Street. Mr. Reeder reaches into his right pocket, again, grabbing a cigarette. And then the police car stops, with the only person stating that Mr. Reeder had a gun being this now disgraced former officer. And not only that, but the evidence that was not turned over in this case also did support the defense strategy at trial. Now, the prosecution states that whether or not there was an adequate investigation or whether or not they properly secured the firearm were not relevant to the defense strategy, but this is clearly not supported by the record in this case. Defense counsel asked repeatedly whether or not they had submitted the gun for fingerprint analysis or they had done any DNA testing, if there was anything beside the word of this one person that connected Mr. Reeder to that gun. He asked whether or not they questioned any other person in the crowd or whether or not they went to a different person before they got to Mr. Reeder. And quite simply, he stated in closing, where is the investigation? The evidence that was not disclosed here would have helped or directly
No, sorry.
Okay.
Just clear my throat.
would have directly aided his defense strategy at trial. And therefore it is material. Indeed, supplied with this impeachment information, counsel could have placed before the jury evidence that showed that Mr. Elaine had been found derelict in his duties, had trouble remembering accurately details of his arrest or had lied about details of his arrest, was formerly tagged high risk by his department, had quit under the cloud of an investigation into an unreported use of force incident, and had his reapplication to DPD denied for not being a good fit. The jury could have been made aware that they were being asked to rely on the word of a disgraced former officer. And for this reason, again, we do think that this evidence was material. Again, Mr. Elaine was the only witness to say that Mr. Reeder had a gun. The evidence that was suppressed by the prosecution clearly impeaches his credibility, and it directly supported the defense strategy at trial.
All right, I see no other questions.
Okay.
Thank you, Your Honors.
Thank you.
So, thank you. This matter is submitted. Move on to item number 17, docket number 372067, Osam Alik versus EES Coke Battery LLC. If I pronounce that correctly, please feel free to correct me. As I said, okay. Oh, as I said yesterday, Anacoletica has been pronounced a number of ways.
May it please the court, Joseph Lucas appearing on behalf of the plaintiff appellant Assam Alloway,
All the way.
kind of like all the way.
Yep. Gotcha.
And this is an appeal from a decision by the Wayne County Circuit Court granting summary disposition in a court case. My client was employed by Lake Transport. He was injured while making a delivery of caustic soda, a hazardous substance, to the Coke battery plant on Zug Island. This happened back in December of 2023. It's our position in this appeal that the trial court got it wrong. He erred. Judge David Allen is a judge, in my estimation, one of the best judges on that court.
Great judge.
Yes, he is. But I think he was wrong in this case. It's kind of a convoluted fact story. But
I
basically,
don't think it's that convoluted.
I don't either.
We understand.
I think we
mean,
understand the facts.
He
He
was
drives
trying
up.
to hook it up.
The guy didn't come outside to tell him. He didn't have the radio. He puts the caustic pipe delivering device in, and his theory is it was their negligence. And your theory is there's a question of fact.
that's exactly my position. It's a question of fact. And primarily because the law is that in every contractual undertaking, there is a duty arises to exercise reasonable care.
They were the ones that were responsible for opening it, right?
Yeah, he could not open it.
Right, that's
Coke
my,
battery.
that's my understanding. So I mean, I think it's
It could only be opened by
by,
Coke battery, enclosed
Right.
by Coke battery, and their own standard operating procedure states that. And everyone in
You
the,
allege they were supposed to have a standby guy with a handy walkie-talkie or a cell phone, and he wasn't there. Also, yeah. So
yeah, and say there's a lot of factual ins and outs, but the bottom line being he was there to make this delivery of material owned by Coke battery into a storage tank owned by Coke battery.
Right.
And he had to do it through an inlet valve, which was controlled by Coke
and
battery.
there's no, he wasn't a co-employee of Coke Battery, and there's no workers' comp is the sole remedy as to this claim.
No,
correct?
no,
Yeah.
there was a workers' comp claim with regard to his employer, but not Coke battery.
Yep.
In this particular case, we submit that because Coke battery had the control of the valve, and because there's a factual dispute whether they were telling him it's open, that does create a question of fact, which precludes summary disposition. And I know in the defense appellate brief, they spent a lot of time talking about Mr. Alloway made this mistake and did this wrong, and that the accident is solely and completely his fault. But I think it's important to stress that everything he did wrong was predicated on the misinformation he received.
But isn't the problem here that the judge dismissed the case because he found there was no duty?
That's exactly right.
That we have to start with the duty. He said there was no duty to the plaintiff as an invitee onto the premises. So that, and that's why he dismissed it. That's my understanding.
Well, that is correct. Your understanding is, he did say there was no duty. And I submit, number one, that because this was a contractual undertaking by Coke battery, a duty arose. And then when you put it in the context of this delivery of hazardous
He's a
material,
business invitee, wasn't he?
Yeah.
material controlled by federal regulation on their premises with a valve that only they could control. And a duty does arise just in the context of negligence. If you viewed it from a premises liability point of view, he was an invitee on the premises, a commercial invitee, and under Michigan law, a commercial invitee is owed a duty of reasonable care. And any negligence by the invitee really goes to breach and comparative negligence. It doesn't go to duty at all. Well, that was the holding of the Kandal Al Said case in the open and obvious context. So I'm saying that in the negligence theory, a duty arose because this was a commercial or contractual undertaking that he was performing in the context of being on their premises and depending upon them to open this valve and depending upon them to give them proper information about whether it was open or closed. And because he was told it was open and because his caustic soda was not flowing, he drew a number of incorrect conclusions. That something was wrong with his hose, that perhaps the material had frozen because caustic soda can freeze at a much higher temperature than water. And as a result of those incorrect conclusions, he attempted to disengage his hose while it was still pressurized and had an explosion of caustic soda, which hit him in the face. In our response to their motion in the circuit court, we put forward the affidavit or a report by an expert. And that expert said that Coke Battery failed to comply with federal regulations and having someone attend the unloading. He failed to comply with Coke Battery's own internal standard of practice, which required that someone, their employee, attend the unloading until the material is flowing and both open and make the phone call to open and close the valve, and that they didn't comply with federal regulation in reporting the spill of the caustic soda on their premises, which is again required by federal regulation. And I submitted that all this evidence of negligence, in the context of a summary disposition motion, should mandate that the motion should have been denied. I know in the brief, they argue that we didn't allege a premises liability claim. Not accurate. Our complaint alleges that the valve itself was defective because it was closed when he believed it to be open, and that in the trial court, argument was had on the issue of whether he was an invitee and whether there was a duty in the context of him being an invitee, and whether this was a defective condition on the land and or a dangerous condition. So basically, the testimony unequivocally was that this was a shared responsibility in unloading this hazardous material. Mr. Alloway himself could never unload it alone. He had to hook up the hosing, but the valve had to be opened by an employee of Coke Battery and had to be closed by an employee of Coke Battery. And therefore, the accident certainly raised a genuine issue of material fact, which should have caused the circuit court judge to deny the motion for summary disposition. So I would request the court to reverse the decision of Judge Allen and remand the case to the circuit court for jury trial. If you have any questions, I'd be happy to answer them, although it sounds like you have a pretty good grasp of the intricacies of the delivery.
No question.
None,
I
no,
see
none, none here.
You have
Thank
plenty
you
of,
very much.
you have
He
plenty of
retired.
time for rebuttal.
Is that retired? Is Judge Allen still actively serving, or has he retired? Judge Allen? Was he still on the bench? Okay, good. Yeah, I ran into, okay. I think he's younger than I am. I'm sure he's younger than I am, but I thought heard some. Okay.
Good morning, John Travis Mahalik on behalf of the defendant here, EES Coke. There's a couple of things I want to respond to, and I'm certainly happy to answer any questions. First, I think a lot of the things that plaintiff brings up here are comparative negligence issues, and that's not what's on appeal today. We're talking about duty, whether EES Coke owed an independent duty to the plaintiff here. And I think there are preservation issues because the contractual undertaking, the inherently dangerous storing of hazardous chemicals, those were not brought up with the trial court. Those were not argued in the trial court. The briefing and the oral argument in the trial court was limited to federal regulations and standard operating procedures creating a duty. And the court pretty specifically rejected that. And the only count that's in the complaint is that the valve was defective. It's a negligence count. It's not a premise liability count. It's a negligence count that the valve was defective. And the testimony here is universal. It wasn't defective. So we have entirely new legal theories and arguments that are on appeal. I won't get into them. I think we've talked about them.
I noticed though that in answer to or for the summary disposition motion, I don't know if it was you or another trial counsel did argue premises liability. There were premises liability arguments made.
That's correct, Your Honor. Yes. If the court considers this alternative theory of liability, here's why it's wrong, but it wasn't argued. It wasn't ruled upon by the trial court and it wasn't argued by the defendant or the plaintiff
Well,
here.
it was ruled, the trial court did say he found that there was no duty and that the plaintiff was not an invitee that would give rise to a duty under premises liability. That's my understanding.
I think it was conceded that he was a business invitee, right? And the trial court ruled that there was no duty to him as a business invitee under these facts, is my understanding of the trial court's ruling. But again, if the court interprets it differently, the issue with respect to duty here is control. Who controls the instrumentalities that cause the injury here? Here, all of the plaintiff controlled the caustic, plaintiff controlled the hose, plaintiff controlled the pressure in the tank and the hoses, plaintiff controlled the safety measures. Yes, EEOC controlled the internal valve on the caustic storage container, but that's not what caused the injury.
Do you agree that he has alleged that someone from your client informed him that the valve was open? Is
He's-
that alleged?
That's alleged, but I think that's irrelevant for.
How, to quote my wife's preacher, here, how is that not, here ends the reading? I mean, you know, how is there not then a factual question that the plaintiff is entitled to a petite jury to make a determination on this issue?
Because the statement on whether the valve was open or not is a comparative question. It's not a duty question, right? I think it's irrelevant to whether we owed him a duty at the outset.
So you run a business that uses chemicals that can dissolve metals. And you're suggesting that under the laws of the state of Michigan, you don't have to, and you ask people to come on there and ask them to bring the corrosives that will dissolve these metals. And the law in the state of Michigan is you don't have any responsibility to make sure that your people are running your gear right before the guy who's delivering the stuff that you're paid for is delivered properly. That's what the law of Michigan is.
The law in Michigan is that we don't have a duty to someone who acts careless. And so
Is that not a factual question, my friend?
because that goes to comparative negligence. Like our argument here, let me try to state this a different way. Our argument is not plaintiff was careless and thus there's no duty, right? Our argument is that the hazard here is not a condition of the land for premise liability claim, right? It's not a condition of the land. The closed valve did not cause the caustic to spray. Full stop, right? And now what we're,
Sure it did.
no, the
People were
pressurized.
turned on as it was supposed to have been when you paid somebody to
open.
deliver a corrosive material to dissolve metals. It wouldn't have happened.
But the testimony here is not that the closed valve caused any spray, right? Nothing sprayed, nothing went wrong until plaintiff made that decision to uncouple a pressurized hose.
Well, that's sort of like saying if it weren't for original sin, we wouldn't have to, wouldn't have churches. I mean, wow. Okay. I understand the argument. I understand it.
It's the duty question is the harm here. What we're trying to do is create every miscommunication or every misstatement in the context of an employee as now creating that duty. And that's not what happened. Here, there was no injury from the closed valve. The closed valve was, or the instrumentalities of the injury were exclusively controlled by plaintiff. He could have walked away from the truck, there would have been no injury. He could have depressurized the hose, there would have been no injury, right? The statement that the valve is open did not cause the injury. And so that's a comparative issue. Here was there a duty to protect the professional driver who controlled the offload from doing things in a manner that's unprofessional or in a way that violated their own safety measures. And I think Judge Allen got it right that there's no duty here, right? We're not the one who controls his offload. He controls his own offload. We don't have the duty to stand next to him and say, do this, don't do this, don't do this, now do that. That's not how this was. This was, you are responsible for unloading this and doing it safely. Yes, the valve was not opened, but the valve being in a closed state was not the cause of the injury, right? If we want to get into proximate cause, we can talk about proximate cause because we talked about it on the appeal or in our appellate brief and in the trial court, but the statement, whether the valve is open or closed, in our view is irrelevant because it doesn't go to duty and it's not the proximate cause of the injury. I think it's very similar to what the Brown versus Live Nation case held. I think that's where, right, what we're doing is we're kind of transforming this into we're reframing it from premises to conduct, right? We're saying your conduct did this, but this is a premise case. And so our argument is that this isn't a hazard on the land. It's not a condition of the land, right? The closed valve is a closed valve. That's not in and of itself a hazardous condition or a premise liability case. It only became an issue when plaintiff didn't do what he was supposed to do. And then when plaintiff, the instrumentalities that he controlled were done inappropriately. So in and of itself, in a premise liability case, the fact that a valve is closed or even that plaintiff was told it was closed, that's not a premise case, right? Because it's not a defect of the land. Certainly happy to answer any more questions, but from a duty perspective, I think we maintain that we didn't owe him a duty.
I think we understand the
Thank you.
argument.
Thank you.
Rebuttal?
Just a very quick rebuttal, if I might. I think counsel is mistaken when he argues that premises liability was not discussed at the trial court level. My own brief, the brief I filed in the circuit court, states plaintiff maintains that a closed auto valve reported by the defendant who is in the best and only position to know to be open is a dangerous defective condition of the premises. More so when the valve is used solely to transfer a highly dangerous substance. And in their response brief, they say that almost something directly opposing it, saying here there is no evidence that the Coke battery storage tank inlet valve was a defective or somehow a dangerous condition on the land. So premises liability was certainly an issue discussed at the trial court level, and part of, as the judge pointed out, part of Judge Allen's opinion was that he was not an invitee, which I think is incorrect, given his reason for being on the premises. And I think another point that ought to be addressed briefly, granted, that valve itself did not cause the caustic soda to escape, but that valve was one step in a chain of causation, which caused the hose to be overpressurized because Mr. Alloway thought it was open. So he kept putting more air pressure into the hose to push it, and also caused him to believe incorrectly that something must be wrong with my equipment. So I should disconnect this hose and take it back to Lake Transport and find out what's wrong with my truck. So that valve, although it wasn't the last step in the accident sequence, was a critical step which began an accident sequence resulting in an injury. And again, I would submit that because of that, Judge Allen got it wrong. There is a question of fact that should have been submitted to a jury. And I would ask the court to reverse his decision and remand it. Thank you.
Further
Thank you.
questions? Thank you both. The matter is submitted. We'll move on to item number 18, docket number 374356, Robert Banker Senior versus Citizens United Reciprocal Exchange.
Citizens United, isn't that the big political speech case? Oh, appropriate the day after the election.
Mhm.
Good morning. May it please the court, Courtney Evans here on behalf of Appellant Cure. There was a number of different arguments raised in all the briefs filed in this case, so I just would like to take today to emphasize what we believe are the key points in this case. There is,
Can I go back to your name?
yes,
Can you,
Courtney Evans.
Courtney Evans?
Yes.
Okay. I was trying to see if there was. Okay. All right, thank you.
The first is there's one undisputed issue in this case, and that is that there was a material misrepresentation that occurred. Robert Banker Jr. failed to inform Cure about the other resident relatives in his household, which do include his father, who is the plaintiff in this case, Robert Banker Sr., who was the regular driver of a 2000 Jeep Cherokee that was covered by the Cure policy. There are two disputed issues that we find to be the main issues in this case. The first is that the trial court erred by denying Cure's motion for summary disposition because Cure can rescind the policy as to plaintiff, as he was not an innocent third party and was directly involved in the fraud. And second, even if the court agrees that Cure can rescind the policy, the medical provider's claims also fail because they stand in plaintiff's shoes. And even if the court does not agree that those medical providers stand in plaintiff's shoes, the court should nevertheless remand this case for a rebalancing of the equities with a balancing of the equities test that is more directly tailored to the situation involving a provider versus a situation involving an insured or another individual.
I have a couple of questions before you go.
Sure, yeah.
further. What is the evidence that Banker Senior was involved in fraud in procuring the policy from Cure?
So in this case, we have a lot of facts that show he drove this vehicle, one of the insured vehicles, that was the 2000 Jeep. He drove it to work every day. He paid for all the routine maintenance. And so for all intents and purposes, he was the constructive owner of this vehicle, which under Michigan law incurs on him a duty to insure the vehicle. There was testimony.
How does that show that he was involved in fraudulently procuring the policy?
So he testified, and his son testified as well, that he had asked his son to get insurance on this vehicle. That's how they always handle things. They handle it together. And he testified that he paid his son for his portion of the insurance. And he testified that his son gave him the insurance to put in his car. And even if he was not the individual that sat down and filled out the policy, that's not required. We have the Hamoud case, which is
Right, but the issue is whether or not there's a disclosure that there's more than one resident other than Junior living at the house. And is the tape recording, is that in evidence, the transcript that we're able to consider on the appellate record? I think it is as well.
The transcript there's not a transcript of it, but the recording is. It's exhibit I.
Okay,
Yeah.
so that's in evidence on the appellate record, correct? Okay, you've listened to it.
Yes.
Okay, nowhere does your employee say, are you the insured? Nowhere does your client say, who lives there? It just does not happen, right?
Correct.
Okay, so if there's no evidence, the one thing that you have where Senior is communicating with your client, there is no representation about who lives in the house. There's no question from your client about who lives in the house. How was the trial court wrong?
So again, I would point this court to the Hamoud case, in which case this court found that the party in that case, it's very similar. There was a car that was driven by both him and his brother, and he asked his brother to get insurance. His brother did so, but his brother left him off the policy for whatever reason, but he testified that it was so that it would make the policy cheaper. And in that case, the court found that
Who said it was going to make the policy cheaper? The guy who was claiming the benefit?
I believe it was the guy that procured the policy, and then his brother, who was not listed on the policy, was attempting to.
And did he say, my brother knew this?
I believe so.
Okay, again, like the last one, here ends the reading. You don't have any evidence of that in this case at the trial court. In the case you're relying on, based on what you just said, there was evidence that he knew about it. It's completely different facts.
Respectfully, Your Honor, we find that there is no way that plaintiff did not know about the misrepresentation in this case.
Right. I mean, you're saying that.
Okay,
But
here are the words. Where's the evidence?
Under Michigan law, he has a duty to know what's in the insurance policy that is insuring the car that he is the constructive owner of. And so for him to not look at that policy, he had a duty to look at the policy to see that he was not insured under it and to correct that so that he had valid insurance on
So
this.
he had constructive knowledge or actual knowledge?
He at the very least had constructive knowledge. I know there's some question of whether He had the policy in his hand when he made this call. There is part of the call where he says, this is my policy to the individual.
Right, but again, that is due to this senior, junior status and nobody asks. And no, and nobody discloses, hey, I'm junior, I'm senior. But although he does say I'm calling up for my
Because I'm
son.
calling for somebody else.
Yes,
I agree with that, but the point here is you have to look to whether this was an innocent third party. And this is not like a lot of other cases. I know in the case Pioneer State, we have kind of a very typical innocent third party. It was a son. He was not listed on his mother's insurance, but he didn't have his own car. He didn't have his own insurance policy. And when he attempted to seek insurance under his mom's policy, the insurance company rescinded the policy. In that case, he had no reason to look to that policy. There was no reason for him. So he was, in fact, an innocent third party. He was not involved in the procurement of that insurance. Whereas here, plaintiff asked his son to get this insurance policy, drove every day, was the constructive owner of a car that was on that policy. And so he is so intertwined with this policy that he can't now sit back and say that he had no idea what was going on, because under Michigan law, he had a duty to know what was in the policy and he had a duty to correct that when he called, which is something that Banker Jr. testified. He had told his dad, hey, I want you to add yourself to this policy. And we obviously don't have that in the call. So for those reasons, we argue that he was not an innocent third party, and the trial court erred in that matter. I just want to briefly turn to the second disputed issue, which deals with the provider's claims.
Yeah, and that's what I wanted to ask you about. How does this court even have jurisdiction over providers' claims when you resolved their dispute by a consent judgment? Why
So
would we have any jurisdiction over that?
the jurisdictional issue here is that Cure maintains that because the provider's claims are in effect derivative of the plaintiff's claims, that they are looped in with all of that. But we also just ask that there is a need for some clarification in this area of law, a clarification for a new standard test that goes beyond the Pioneer State factors to determine how the balancing of the equities should occur when a provider is involved.
because providers now have a direct cause of action.
Correct. Under Michigan law, the providers do have a direct cause of action.
Right.
However, their MCL 500.3112 only allows the provider to file suit when there is an existing no-fault claimant who meets the requirements for coverage. And so even if you do not have the same situation as before the 2019 reforms, there is still this kind of inherent tie between the provider's claims and an insured's claims, and the two can't be separated logically.
Well, to Judge O'Brien's point, you entered a consent judgment here and now you're appealing it. And that's something that we do not allow under Michigan law. You can't consent to entry of a judgment and then appeal it without there being some, I guess, some language in there saying, or we're.
Yeah,
you know,
preservation.
yeah,
Judge O'Brien and I had
contingent
walked down
on-
this path together many times, and the Supreme Court has decided Judge O'Brien is correct and Judge Feeney and I were incorrect. So we both understand this area a bit.
Unless you have any other questions, I'll save the rest of
The
my
moral of
time.
that story is always listen to what Judge O'Brien has to say.
Seems like a good way to go.
Wise advice. All right.
Thank you.
Hey, please the court, Martin Hogg on behalf of Surgeon's Choice Medical Center. Yes, my client was the provider that resolved the claims. Was a little surprised to see the briefing seemed to be trying to affect how claims affect parties situated like my client at the appellate level. It's perhaps why Ascension St. John is not part of this appeal, perhaps didn't even read the briefing. But in any event, a couple points. The Van Dyke case actually did alter those pioneer factors slightly to account for the provider claim. I laid it out in my brief as to why as those were applied to this case, why rescission still wouldn't be appropriate, even if it would be appropriate as the banker senior. A couple other points, the Hamoud case, has a direct quote, "Under these circumstances, plaintiff was actively involved in defrauding defendant and was not an innocent third party." So what, as I think recognized by this panel,
Are you reading the room?
yeah.
Okay.
So with that, I will cede my time to Ms. Kramer, unless there's any questions. Thank you.
Ms. Kramer will try to read the room as well. Good morning, judges. Caitlin Kramer on behalf of Allstate. Allstate is the MACP assignee in this
yeah.
case.
Are you okay sitting at that table or no? It's
I know,
at
usually
Appellant's
I,
counsel.
usually
Someone is
I'm not always.
having a little,
Martin and I
you
don't
need a
always
GPS
agree.
that goes on. It seems.
It was a little funny this morning, I won't lie. I think you've all highlighted the issues here. There is not evidence in this record to support the constructive knowledge argument that sister counsel is making. So if plaintiff was an innocent third party, then the balancing was appropriate. It is reviewed under an abuse of discretion standard, and I see no abuse of discretion here. With that, any questions for me for Allstate?
For me,
Thank you. Short and sweet.
thanks.
Okay. And is there rebuttal?
I don't have any points on rebuttal outside of what's in our briefs. I'll rest on.
Also reading the room.
Thank you.
Thank
Okay,
you.
All right.
Thank you all. Yes. Thank you for the briefing, and this matter is submitted. We'll move on to item number 19, docket number 375503, Beaumont Hospital Taylor versus State Farm Mutual Auto Insurance Company.
This looked like a lot like naval aviator pin on your lapel there.
I was once one,
Yeah?
many
What-
moons ago, Your Honor.
What did you fly?
P3 Orions.
Oh, God, the whirly birds. Okay. All right. Off of what ships?
I was out in the Pacific, and then I spent a lot of time in the Middle East when the 20-year war kicked off. I was
Yeah,
on
yeah.
the front end of it.
Okay. All right. Well, thanks for your service. Semper
My
Fi.
pleasure.
Appreciate it.
Good morning, Your Honors. Ryan Duffy on behalf of the appellant Beaumont Hospital in this one. I know there's been extensive briefings. The court has indicated that they've read them all. I think this is about I think it's simple if you really look at the transcript from the hearing. The trial court judge basically granted their motion and dismissed my client's claim, saying because it was experimental.
Right. This is a
that-
hyperbaric chamber, right?
It's an
Yeah.
off-label, not an experimental.
And so that's the 2 points. I don't think we get to the experimental standard because it's off label, but even if you do, the Crone case really does state just because it's experimental does not mean it's not covered. And then you go down the reasonable and necessary kind of evaluation, subjective and objective. I think there's plenty of testimony from the treating physicians that there is objective evidence that it was helping the
That this
patient at
was
the time.
helpful to. right.
Yes. And so we believe at a minimum, there's a question of fact, but they didn't have any testimony to rebut our treaters at the time. But I don't want to go through everything unless the court has some questions. Happy to
I don't
answer
know.
them.
May not win, but seems like you get to try it. So.
We have no questions.
I don't have any.
Yeah.
Did learn new words in this case.
Good morning, Your Honors. Jonathan Freshour on behalf of State Farm. It's great to see you.
Good morning.
I am also reading the room, so I will be brief.
So good. So good.
Doesn't always happen.
I understand the distinction between experimental or off-label. I think though the question at the core of it is this a procedure that's generally accepted by the medical community for treatment or care of a specific and diagnosed injury? And I understand that the transcript of the trial court's ruling on experimental is a little confusing, but the trial court speaks through its written orders, and it concluded that this treatment in its order was experimental. I think there is plenty of evidence that I'm going to refer to hyperbaric oxygen therapy as HBOT. Otherwise, I'll start saying who knows what, trying to repeat it. But there's plenty of evidence that HBOT is probably helpful for everyone. It is a great thing to pump oxygen into your body. But there is no testimony in this case that HBOT was effective for the behavioral issues that
Right, but
DK's
wasn't there
mother-
specific testimony that after the accident, this I think teenager when the accident took place, or adolescent when the young man when the motor vehicle accident took place, subsequently gets the HBOT. And isn't there some licensed physician that says, I looked at the film, so the independent radiological studies from immediately after the accident and after some of the HBOT treatments, and it looked like there was venous correction and there was physiological improvement in addition to mom saying and the young person saying, I think things are better with this. I mean, don't we have first, somebody has said, we got CT evidence or MRI, just don't remember which it is. That's first question.
It's a great question. I believe it was Dr. Patel, and I think he was looking at an MRI. And what he testified was he believed that his first treatment was helpful and perhaps his second. But then we're talking about 150 treatments, and the rest of his testimony is that seemed a little odd to him as well. But
isn't there this physician from Toledo who's also a licensed medical professional that says, mom says it's improving, patient says it's improving. When I get that, I like to continue with the continuum of care that everybody who's the customer of it says is improving.
I would clarify that it's mom says it's improving, but that Dr. Hasib also testified, I would point your honor to page, I believe it's 15 of our brief, it might be page 20, but there are pinpoint sites there of 6 different instances of Dr. Hasib testifying that he would have prescribed ordinary therapy, but mom was so fervent that she wanted HBOT, but this is a quote, HBOT is considered experimental for TBI treatment. And he understood that. It's also why Dr. Patel, when he did prescribe it, he testified that he didn't have an objective basis to. He was going off subjective statements of the mother. And he told her for that reason that he didn't believe it was going to be covered by insurance. So I think the thrust of the testimony here supports the trial court's conclusion that this was experimental. But with that, I apologize if I didn't read the room as well as I.
No. I ask questions here, and my colleagues might be. I may have some answering to do when we go back to caucus, but no, you read the room just fine.
If your honors have any further questions.
They always say, Jim, you ask too many questions. They don't say that, actually.
Yes, you have rebuttal.
Do they have any questions for me?
I don't.
I would just say that if you look at the testimony as a whole, Dr. Hasib did look at MRIs. He compared a 2018 to a 2022 after. That's where you saw some difference. They also said they reviewed the neuropsych reports, which were objective in nature and considered objective and saw improvements. So it wasn't as simple as I think it's being laid out. But with that, unless the court has any other questions for me. Thank you.
Thank you.
Thank you. That matter is submitted.
I'm okay.
Okay, all right. We're going to continue with our 11 o'clock call. We're going to call item number 20, docket number 375350, Shamir Cheryl Cooks versus Citizens Insurance Company of the Midwest.
Excuse me.
Good morning, Your Honors. Beth Wilcoxon representing the plaintiff appellant Shamir Cooks.
You may proceed.
Thank you. This case involves a March 24, 2022 accident. The plaintiff was driving her sister's vehicle. She didn't have her own insured vehicle. Her sister's vehicle was insured with Progressive Insurance. She lived with her sister at an address in Brownstown. And she, as I said, she didn't have any of her own insurance. She made a claim with her sister's Progressive HIP insurance based on her status as a resident relative. Progressive ultimately denied that claim following an unrecorded statement from the plaintiff's sister that she lived at a different address from the address that she had insured the vehicle at. Right? Okay. So the statement occurred on November 30th, 2022, March 24, 2022 accident. So the statement was November 30, 2022. And we filed a claim with the Michigan Assigned Claims Facility on January 14, 2023, since Progressive denied coverage because of the misrepresentation of where the vehicle was garaged when it was insured. We disclosed the existence of the Progressive policy on the MACP application. And MACP assigned to defendant citizens. We had submitted all of our PIP documentation, our claim for medical expenses and wage loss and household replacement services originally to Progressive, and we then submitted all of those same proofs to citizens. Citizens acknowledged receipt of all the submissions. They issued an open claim letter. They sent my client to an IME, which she attended. They ultimately denied benefit. It was a chiropractic IME, but she was treating with a chiropractor. They issued a denial effective May 5, 2023, and we filed suit in July of 2023. So clearly within a year of the specific denial. We go through the case and defendant then files its motion for summary disposition, excuse me, saying that there really was coverage with Progressive when there was clearly and provably not coverage by Progressive. The trial court granted that motion, and the trial court erred because it said that it was dismissed essentially pending determination that there was no coverage by Progressive, but we had already provided proof of that no coverage by Progressive, albeit late in the day, because not all adjusters are geniuses and not all claims departments are functional. But I finally obtained confirmation that the coverage had been not denied based on the residency and the insured address issue, which we knew about from November of 2022. And that was in the form of a voicemail from an adjuster, which I submitted the tape of the voicemail, and I did a transcript of the voicemail in response to the SD motion. So my position is that the trial court erred because there was evidence that Progressive did not provide coverage, and that they should have denied that motion. Defendant has said, well, it's not on MACP to find your other insurance, but that's not what we're talking about here. We already knew about the other insurance and we pursued that claim to the point where there was never any coverage afforded by that other insurance. This was a motion for summary disposition that the defendant had the burden of proof on. So given that evidence, defendant didn't offer anything to say, well, Progressive actually did provide or would have provided coverage for this accident. In fact, there was evidence that said that they would not. So it's our position the trial court erred. There was also an issue about submission of the 1 year back, submission, 1 year back applicability to the actual PIP submissions. The trial court did not rule on that. I will discuss it if the court wishes.
No one has any questions. Thank you. You have time for rebuttal.
Okay, thank you.
Good morning, Your Honors. Joy Glovic for Defendant Citizens. First of all, the so-called evidence of that the claim was denied by Progressive because of misrepresentations is not supported by the record whatsoever. The only written denials that ever came from Progressive were stated that the claim was denied, which were, those letters were sent to plaintiff's counsel, that the claim was denied because Ms. Cooks failed to cooperate in Progressive investigation. Specifically, Progressive was asking for additional information to confirm the residency. That was never provided. The claim was denied twice by Progressive because of the failure of Ms. Cooks to cooperate. It was not denied because of misrepresentations as to the garaging address. The policy remained in force and effect, and that's the only evidence that was ever provided to the court or supported. Plaintiff relied or mentions a voicemail message that was left from a Progressive representative, which was made literally over a year after the complaint was filed, not against Progressive. Progressive was never named as a party. And the only thing that at best that voicemail indicates that the claim was denied because of non-cooperation, again, now non-cooperation and order of priority, which what plaintiff fails to realize is that order of priority statement means that because she didn't cooperate in the investigation, there was no proof to corroborate that she actually was living with her sister, the named insured under Progressive policy. Otherwise, as we filed our motion for summary disposition, clearly providing the facts that supported that Ms. Cooks resided and was domiciled with her sister, who was Progressive's named insured at the time of the accident. There was unrebutted support that Progressive policy remained in effect. It was never rescinded. It was never. Otherwise, the only thing that supported was that plaintiff says there wasn't coverage is the denials, which, as indicated, the only written denials that ever came from Progressive, which we subpoenaed Progressive's file. We asked for the denials from plaintiff in discovery. They were never provided. The application for benefits referenced a denial letter. It was never provided with the application. We found out when we subpoenaed Progressive's files that the claim was denied for lack of cooperation. Plaintiff can't just choose to say, oh, well, I'm going to ignore that there's a priority statute and that I'm just going to claim benefits to the MACP and ignore the fact that she's based on her own admissions, she was domiciled with her sister. I mean, that would provide and mandate coverage under 3114 subsection 1. Again, once there is applicable coverage, a claim is not eligible for benefits through the signed claims plan under 3172(1)(a). If there's identifiable insurance, regardless of whether the insurance is applicable, there's still no coverage through the MACP under 3172(1)(b). At best, there is still identifiable coverage through Progressive. Even if the claim was not applicable, which again, there's still no, at best, there was denials for plaintiff's failure to cooperate, which is a contradiction to her obligation to diligently pursue a claim under Griffin and Trumbull and to pursue claims for benefits in order priority mandated under 3114. The case law that was cited and discussed in our brief unanimously supports that if there is coverage or if there's identifiable insurance, even if there's issues with whether or not a plaintiff can even still pursue those benefits through that insurance, it's still applicable or identifiable coverage that precludes the ability to claim benefits through the MACP. That is what we have here. The trial court was correct in granting our motion and dismissing citizens from the case. And since we didn't go into the 1 year back issues, I don't see a need to discuss them further, but.
We have no questions. Thank you. Thank you. Rebuttal, Ms. Wilcoxon.
Yes, very briefly. So in just to be clear, the alleged lack of cooperation was lack of cooperation of the insured, not my client, not Ms. Cooks, not the plaintiff. The voicemail said the claim was denied by Progressive due to order of priority. She does not return to the policy address. That is documented demonstrably true. She did not live in Redford. She lived in Brownstown. The vehicle was insured in Redford. That's consistent with the non-recorded statement, which I've made representations what she said, but the documents support that, and she would certainly have, the sister would certainly have testified to that. So the fact that there is, that you can say, look, there's an insurance policy, that's not the end of the story for MACP. The whole purpose of the no fault statute is that a person gets insurance, gets their PIP benefits paid. They get that benefit. And here, unlike the case law that defense counsel cited, my client did everything she was supposed to do. She pursued her claim against the known insurance company. She cooperated regardless of what the language in their letters were. It was clearly the insured's cooperation that was at issue, not my client's. But then the coverage was denied, and then she correctly made her claim with the MACP. So the fact that there exists an insurance policy, if it isn't going to cover her, if it's not going to provide coverage, it's not valid insurance, and MACP needs to step in. That's what it was designed to do. So the case law that defense counsel refers to is all distinguishable in the following way. So the university neurosurgical case and the Elias case, and these are all non-published opinions, but regardless, if the rationale is persuasive, in university neurosurgical, the plaintiff didn't ever, they just ignored the identifiable and arguably applicable insurance. And in Elias, they identified them, but they didn't put them on notice in time. So that's different. That's not what we did. We did what we were supposed to do. We put them on notice. We pursued that claim. We only went to MACP after that was fruitless. The Fulton and the American Physio cases didn't even address that issue. And the Henry Ford and Intigon case had Intigon as a defendant, and it was determined that it was based on it was a provider case, and it was based on an ineffective PIP opt-out. So it was not an issue of whether there was coverage afforded by the identifiable insurance. So those cases don't address our facts. I'm not going to rehash if anyone has a question.
I don't see any.
Good.
All right, thanks.
Thank you.
Thank you both. This matter is submitted. I'll call item number 22, docket number 374771, Henry Ladarian.
What about 21?
Oh, shoot. I did. Sorry. I apologize. I'll call item number 21, docket number 375763, Szymanski's Law versus Elizabeth Eldridge.
All right.
Morning, Your Honors. Michael A. Szymanski on behalf of the plaintiff. I, of course, will rely on my briefs, and I think everything is pretty well set forth there, but I want to emphasize a couple of things. First of all, the main, a very clear error that the trial court made in the case that we have on appeal is that she says near the end of her opinion that the contract claim that I'm suing on is based on charging lien, which was denied. That's backwards, as I've set forth clearly, and I've cited the cases. There's two independent actions. There's the obligation on the debt, and a security interest is a separate thing. So that's one thing. Then the other main problem here is that both Well, the Court of Appeals and the trial court rulings in the previous case, the Eldridge case, are both argued as saying that I'm not owed any money and the contract is denied because of that. The clear import of the prior rulings is that they just declined to enforce the charging lien.
Right, I was on that panel.
Pardon?
I was on the prior panel. And in this case, regarding the charging lien,
Yes,
where we denied that,
yes. And you denied the enforcement of the charging lien, correct?
affirmed the lower court's ruling.
Yeah, and the lower court said it was going to dismiss the charging liens.
That's correct. The security interest.
Yeah, the security interest. So what is being sued on in the instant case is the contract claim. And once again, the contract was written, signed, agreed to. And as I pointed out, the agreement was that when Elizabeth was collected money later on, I would be paid the portion that I had allowed her to take from my original fee trade.
Right, it was a deferred.
Yes.
payment.
So, none of the rulings in the prior case say anything about, say anything other than that the lien is not enforced. And basically, other than that,
You can't get it out of this pot of money.
I'm sorry,
You can't collect out of this pot of money.
right.
Okay.
Yeah, it wouldn't allow me to take a lien on the proceeds that were there. So that's been distributed and that's all done with. So, other than that,
Why weren't you required? This is involving legal services that took place more than 11 years ago, correct?
yes, Your Honor.
Why were you not obligated to bring these claims in the previous litigation? How is an 11-year-old dispute over whether or not you got paid enough money? How is that appropriate?
Your Honor, I filed the charging, I filed a motion for a charging lien.
Mhm.
And that was denied based on equity. There was no requirement that I sue Elizabeth on the promissory note in that case. I was,
Why aren't you required to bring any and all possible claims at a time when you have them?
I brought the claim timely.
You brought the charging lien and you litigated it,
Yes,
but
and Your Honor, I had
and you lost, right?
and I lost.
Okay,
on
so
the charging.
how are we not done?
Because the charging lien is a security interest and there's still an underlying obligation on the debt. And that is governed by the contract statute of limitations of 6 years. And as the trial court found in this case, that claim didn't accrue until Elizabeth was distributed the final check, the 200,000 or so,
Which was
out of
when?
which I should have been paid.
When was that distributed?
That was in 2024, I think. Or I'm sorry. Sure, if I have the date handy, Your Honor. Oh, wait a minute. Oh, August 25th, 2023 is when that distribution was made. And that's when I was obligated under the agreement to be paid. Because, if you talk about the time.
Even though your lien was deemed to be unenforceable.
Yes, Your Honor. The lien is one thing, the obligation, the debt is another. And that's what all of those cases that I cited make clear. There's two different things going on there. And if, for example, if a mortgage is defective, that doesn't forgive the underlying note. The analogy here is the same thing.
And I also would point out that the original $117,000 check in 2015 on which my written disbursement agreement was based was an approval by Judge Hegarty at that time, who was presiding, of my fees. Then I let Elizabeth, because she needed to pay her property taxes, take part of that, and she agreed to pay it back. And the agreement to pay it back is what she breached. And I filed on that within the 6-year statute of limitations. So the idea that the denial of the charging lien eliminates anything that I'm owed, just that's not in the case law. And that's all I can say, Your Honor. If Your Honors have any other questions, I'd be happy to address them, but otherwise I rely on my briefs.
Morning, Your Honors. May it please the court, Robert Higbee on behalf of appellee Elizabeth Eldridge. I'll be very brief this morning. Mr. Szymanski sought relief. He's trying to distinguish two things now. He sought relief that charging lien was based on the disbursement agreement itself, and that's detailed in the prior opinion by this court.
Right, but isn't it a separate question? He's going into the charging lien, which is a matter of equity, not the breach of the agreement to pay him, to repay him the monies that he, or am I wrong about that?
I think the only basis for the charging lien itself was the disbursement agreement. If you look at page 3 of the prior opinion of this court, it lays out his 2018 motion.
Isn't that the point of a charging lien?
What's that, Your Honor?
The underlying agreement?
And in resolving that question, the trial court found that he was not entitled to any additional monies.
As a matter of equity.
Okay. And the only basis for that was whether or not the court controlled the disbursement of these funds.
Right, does he get it out of this pot of money?
And that's
And
the only
court
pot.
said as a matter of equity, because she really needed this money, no. So now he's here saying, well, I had the agreement and I filed suit on time on the agreement. And you're saying he doesn't get it because the charging lien was based on the agreement.
That was the only basis for the charging lien itself.
I mean, that's inherent in, okay.
1, 2, that's the only pot of money that exists in this case. There hasn't been any additional funds. And so what the trial court found initially was that you don't get any of these funds, a decision which this court affirmed. And now he's trying to recast that as something different to access these same funds. And we think that that's already been decided.
Has there been any subsequent disbursements to the former client since, well, when were the last, since 2020, has any money come to the client as a result of these divorce proceedings?
Other than the 2023 disbursement that's been discussed already, I'm not aware of it.
And so former Justice Kelly got involved in this case after Judge Haggerty retired. Is that right?
That's correct, Joe.
When's the last time money came to your client that opposing counsel says is a product of the work that I did pursuant to our attorney-client relationship?
I would think he would answer that question by saying it's the 2023 disbursement. August 25th, 2023.
Oh, okay, you just said there's, and how much is the August 2023 disbursement?
I think it was somewhere in the neighborhood of $220,000, maybe 223.
Was that the subject matter, that 200,000 or whatever and change? Was that the subject matter of the previous lien discharge or lien litigation that resulted in the unpublished case of April 11th, 2024?
I just want to make sure I understand the court's question. Is that you're asking, was that the pool of money that resulted in that?
I apologize, I'm not being clear. I want you to tell me, since 2020,
Yes, sir.
when and how much has your client received that you believe Mr. Szymanski says is a result of his work on behalf of your client?
Since 2020, I believe it is the August 25th, 2023 disbursement. That's what he is alleging is the result of his work on behalf of the client.
And that's 200 and change?
220 some odd $1,000. Yes, Your Honor.
Do you agree that at some point your client agrees to provide a percentage of whatever money comes in to Mr. Szymanski?
There was the disbursement agreement. Yes, Your Honor.
Okay.
That dealt with future collections from the receivership estate, which were all subject to court order prior to being distributed.
All right. And in 2024, our court affirms the trial court's 2022 decisions, correct?
Yes, I believe that's correct, Your Honor.
We have never been asked to decide whether or not the 220,000 that came in August 2023 was also subject to the contract that Mr. Szymanski avers existed as far as how to resolve the compensation he felt he was owed back in 2015. Is that correct?
I think that's accurate, Your Honor. Yes.
If that is the case, then why isn't he entitled to whatever percentage your client agreed to pay for money that came in as a result of his services? But why is that? Why? So what's the answer?
One, I think it's a question about what percentage is a result of his services. He's alleging that. You're asking me to answer that question, and I'm answering that directly. I think that disbursement agreement talked about future collections from the estate, which is subject to the court saying what's going to be distributed to who. And he relied on the disbursement agreement prior to all this, saying the disbursement agreement entitles me to funds. And the court said no. And so.
Well, the court didn't say no. The court said not out of this pot of money.
Correct. And I don't think there's anything different.
There's 220,000 different things now than there were before, right? Yes or no?
I don't think there's anything different about the money. What the court is saying is you have this disbursement agreement that you're saying entitles you to funds. The court says you're not entitled to any more funds. It doesn't say you're not entitled to any more funds because of the nature of these monies as opposed to other monies. It says you're not entitled to any more funds. a decision which this court affirms. So even if the court finds that we haven't decided with respect to this specific pool of money, I think the same decision obtains. He's not entitled to recover on this disbursement agreement that he's previously sought relief on.
So you're saying what the court originally decided, it was not as a matter
It's
of
the trial court or the
equity.
court of appeals.
Trial court originally, Your Honor.
I'm asking this judge, not you. I'm asking what
Well,
her question is.
that's an interesting question, isn't it? Because the way I think that it was resolved in this court was as a matter of equity. The court had the trial court had the ability to make that determination. You cannot collect it out of this pot. You cannot, as through a charging lien, you cannot collect it from this amount, this pot of money, as opposed to, is this money owed you? And you're saying the court said you're owed no further monies at all, which is not how I understood the question previously.
And I would just indicate to the court, and I'm looking at, this is part of plaintiff's or excuse me, appellant's appendix. These funds that make up the lion's share of what was ultimately dispersed in 2023 all existed prior to the 2022 decision by the trial court about what should be dispersed to who. These deposits, if you look at the ledger of deposits, they're from 2015, 2017, 2019. There's a deposit that looks like it's from 2020. There's only one deposit that postdates that original trial court decision that ultimately percolated up to the Court of Appeals. So that pot of money existed prior to this. So to whatever, that's why I said it.
Well, it's not in it's not in your client's hands. It's in her ex-spouse's hands, who is refusing to provide the money, right?
That, yes, I think that's
Oh,
generally.
okay. And the whole gravamen, the whole raison d'etre of why they had this agreement that Mr. Szymanski is engaged in is because the guy wouldn't pay the dough. And so he's saying, I want to be paid for the money that I helped you get.
And I'm simply indicating to the court that the receiver provided documentation that says these monies that create this pool that ultimately get dispersed post in 2023, right? They already had been obtained, and the court was aware of that at the time it's made its decision that this pot of money does not entitle Mr. Szymanski to recover any
Is
additional
that
money.
in the record?
Yes, it is, Your Honor.
Case 365601.
I beg your pardon?
Is
it
that
in
in the
prior
prior
case?
court's record? Because if it's not, how is it the law of the case?
Well, it was in the trial court's decision to be sure that the receiver had to provide written updates, written documentation to the trial court about what existed. That's part of the record here.
Right, but sir, if the receiver hadn't received the $220,000 at the time that the trial court made the decision previously that was a subject matter of the appeal, how could it be part of it?
That's exactly what I'm telling Your Honor, that these deposits all occur. They're documented by date. They all occurred prior to that decision, save for one
August 20
$12,000 deposit.
August 25th, you said earlier that on August 25th, 2023, $220,000 came into the estate.
I said it was dispersed. You asked me, what would he say that was dispersed to my client were the results of his efforts? That disbursement happened on July 26th, 2023. Your Honor.
If he's right, let's just assume for a second that he's right. How much money would he have got?
If the disbursement agreement were enforceable and there was a $200,000 disbursement,
Yes.
he would have gotten the $45,000. if he's correct.
Our court has the authority to order settlement conferences and mediation. I am not going to ask my colleagues to do that, but I am going to suggest it is almost beyond my ability to comprehend as a 40-plus year attorney that the two lawyers who are sitting here cannot get this thing resolved by some type of agreement where both sides compromise their claims. That's just little old Jimmy Redford after 10,000 cases in the circuit court as a civil criminal judge and 40 years of lawyering. I mean, really?
I can appreciate that, Your
Anyway,
Honor.
that's, that's neither
Very
here nor
much.
there. We will do our
Right,
duty and the clients will continue to increase the fees.
We understand the briefing and we understand your position. And it's a matter of the intersection between the prior case and this case and what did we say prior? And what did we believe and what did we rule on with regard to what the trial court said in the original case? So, and I think that
Parties
your
are certainly
opposing
free to
counsel-
send a letter to the clerk of court to say, we settled the case after oral argument. And then everybody's done. But
Thank you very much, Your Honor.
yeah.
we can give you some time if that's what you'd like to do. But go ahead.
If I just want to say, I prefer that the court understands exactly what the problems are here, and I don't want to belabor it. I appreciate your attention, and I thank you. If you have any questions, I'm
you.
happy to try to answer them, but
I don't think we have any
No
further
questions.
Thank you.
questions, but I think we
Thank you, Your
thoroughly
Honors.
understand the
I
matter.
think yeah.
All right.
It's not often that one of our responsibilities is to rule again on a claim that we ruled once before. But Judge Letica has that privilege in this case. So Judge Letica, congratulations.
I know, right? All right. Now we'll call item number 22, docket number 374771 in Ray Darian Latrell Howard. And you're here all by yourself, so you have 15 minutes.
Yes, thank you, Your Honors. May it please the court, Emil Trabilsi. I am the respondent appellate attorney. He is a minor. I really want to focus on the importance of this case, and as this court most likely is aware, how there's just a hole in the juvenile justice case law as a whole. We have all these statutes, we have the juvenile justice reform, and not a lot of guidance with case law. So I am trying to be proactive with my arguments, and I want to defend against a misargument because it has been approximately 17 months since my client has been detained and put in detention. But before I begin there, I would say it's uncontroverted that the court failed to comply with its duties, both statutorily and per court rule regarding the detention screening tool, and also failed to make the required findings to remove a child from the home. So those are very important things the court has to do, must do, I think is what the statutes and the court rules indicate. But we're here 17 months later, and this is a case of significant public significance. This is, I believe, a matter of first impression as well. I don't believe there's any published or even unpublished case law regarding juveniles detention, especially post the juvenile justice reform in 2024. And to kind of center that is juvenile justice and juvenile court is often the first time that families come before the court.
Well,
And-
this wasn't the first time for this particular person, right?
Was that?
I mean,
Correct.
you know, I
You're
hear,
such a young man.
I hear
You had
your
a lot of
point, but
contact with the
right,
court.
and
His contact with the system was substantial and frequent.
Agreed.
and so, oh, okay, so there wasn't, as far as I could tell, there wasn't any objection to how the court did what it did, which is put him in detention without reviewing. But at that point, wouldn't the court have already reviewed, and wouldn't the court be in the position of saying, mom's not stopping him from violating, he continues to violate, I gotta stop it.
Those are cogent points, but the court's also required to make specific findings regarding those, not just this kid's continuing to mess up, we're out of options. It's required to do that detention.
The court was pretty clear that it felt it was out of options.
Correct. And I think it's also important to note that it ignored that this child was without a probation officer for about 7 months during the program. The person that's in charge of coordinating these services and keeping this family on track. And also that the respondent also advocated through the counsel of that detention or the hearing that resulted in the detention that the court wanted least restrictive means, right? There's other options. And also indicated that there was record keeping issues with the schooling, and also that the respondent's mother was indicating that there was issues with the drug testing as well. But moving on to my next point, there is significant collateral consequences for my client. As we know that court must use increasingly severity and sanctions as it punishes kids or creates services or plans for kids. And my client is still under the jurisdiction of the juvenile court.
How old is this young man?
He's 18 as of, I think, the 5th or maybe.
He's 7. So he's either 17 or 18.
He's 18 now. All right. Yep. And the juvenile court can keep jurisdiction over my client till 20, right? So we have 2 years of continued services. And if he violates again, or there's an issue or a supplemental petition, the court now is forced to increase the severity of the detention, right? Or the sanction, which if he's already served a lot of time in detention, has no other choice really but to continue another detention order. So I think it's very significant that if he was detained improperly, that the court again make an evaluation at that time that maybe detention is not the first step we go. Additionally, this case and these similar cases are going to be repeated in this court, and they're going to evade review. Just as a personal anecdote, I've had 2 appeals where by the time I get transcripts, the kid's out of jurisdiction was successfully terminated, and they say, I don't want anything to do with court anymore. Please don't pursue my appeal. So I know this issue will be continued to be repeated, and it's really hard, even in a case like this where the appeal was timely filed, transcripts were received ahead of schedule, my brief was submitted timely, the prosecution's brief was submitted timely, and this case actually beat 2 other cases to case call that were older. So everything was very timely in this case, and here we are 17 months later, and this with what I will characterize as a significant violation of the court rule and statute. So I'm just urging the court to put some teeth behind the court rules and statutes and say, this is reversible error. If you don't do this detention screening tool, you cannot detain children. I think that was the design of the statute and the juvenile justice reform.
In some cases, and types of cases, and whether they're civil or criminal or family law, there's a really substantial body of jurisprudence which talks about even if the reviewing panel is convinced that a mistake was made as far as how the procedure was undertaken, that if the reviewing tribunal still believes that the result was the correct one, that we're in some circumstances we're required to affirm, and others were allowed to affirm. What do you make of that concept as it applies to the case that's before us right now that you're representing very capably your client on?
Yes, admittedly, I know of that philosophy. I have not done the research on that. I trust that you know way more than I.
No, don't. That's my law clerk, I'm sure does, but no. I mean, of course, I've read the cases, and that becomes we deal with it frequently, both at when we have motions for interlocutory review, but also for more importantly, substantive appeals.
My point to that is there's no way this court can make that determination, because there's very specific things the court must find in that detention screening tool and consider that's not on the record, right? The juvenile's attitudes towards the juvenile justice system and the police. the ability of compliance with other orders of probation. And there's a lot of things that these tools look at, and we have no record if they, it never existed. So how can this court say that we can still find detention is proper if there's no record of any of those things existing or being considered?
Thank you.
Thank you. All right, thank you so much. This
Excellent.
matter is submitted.
Thank you very much. Have a good day.
All right. We're down to our final two cases and no one is endorsed for oral argument. So I'm going to call them for the record and they will be submitted on the briefing. Item number 23, docket number 371678, estate of Janie B. Sanders versus Cynthia M. Fox. If you're going to speak, you need to come up. Right.
In the filing for the request for oral argument. But
That's
I'm
correct.
here if you have any questions for me. I did want an oral argument, but like I said, it was an
Right.
error.
So, yeah, so our clerk's office contacted us to let us know that you had contacted them.
Yes, ma'am.
And they informed you that you failed to request oral argument on the cover of your brief, which
Yes,
is in our rules. And when you got the notice, that should have reflected on there that you were not endorsed for oral argument. And at that point, you could have filed a motion for oral argument.
Yes.
But
I respectfully understand.
yeah,
It was-
but you understand now that it would be unfair to the other side is if you had filed a
Yes.
motion, maybe they would file a motion. And as you see,
Yes, ma'am.
we
and
often
I-
have
and that's not
double
my intention
arguments.
At all.
I know, I understand, but I can assure you that we've read the pleadings and that we understand the respective parties' positions in this matter and we'll get you a decision as quickly as we can.
Yes, I pray
Okay?
that you do.
All right.
Okay.
Thank
If you have
you.
any
So,
questions? I'm
yes.
willing
I have no
to-
questions, but thank you for being here.
Okay,
Thank
thank
you.
you.
All right,
Have a
thank
blessed
you.
day.
Yes,
All
you
right,
too, ma'am.
so that matter is submitted on the briefing. And with that, I'll call our last case, item number 24, docket number 377660, N. Ray MJK. And that matter, no one is endorsed for oral argument and it will be submitted on the briefs.
Okay, thank you.
And that
Did you-
concludes our case call.
Great, thanks.